Hi class. So my question about the Miss Smith case study asked about durable power of attorney in my state. Um, so as we all know, medical power of attorney is appointed by the patient, and they appoint someone to speak on their behalf when they're unable to make the decision themselves. As we read in the case study, Miss Smith did not appoint a POA in this case study, and that's why many of the problems that we saw came about. So the social worker ruled for an immediate need for a court-appointed temporary guardian to help make decisions on Miss Smith's behalf. So durable power of attorney is a legal procedure that gives authority to a named individual to make end-of-life decisions. And that individual must adhere to the patient's living will. So in the state of Georgia, their durable power of attorney law says all powers the individual may have to be informed about and to consent or refuse to consent of any type of health care for the individual, including withholding or withdrawal of life-sustaining or death-delaying procedures or after-death autopsies and disposition of the remains. The legal requirements in the state of Georgia for durable power of attorney are that it has to be in writing, it has to be signed by a principal, and it has to be witnessed by at least 2 competent adults. And one thing that I thought was interesting is that in this law, the state of Georgia also mentions about how the durable power of attorney can be revoked, and it can be revoked at any time by principal without regard to physical or mental condition, and by 1, destruction of the document, 2, written revocation signed and dated by the principal, or 3, by oral or any other expression of intent to revoke in presence of an adult witness who within 30 days must sign and date in writing confirming the expression of such intent. And then also it mentions that divorce revokes the power of attorney. It also mentions about how if the physician is unwilling to follow the durable power of attorney, it mentions that the physician should promptly inform the agent who is responsible to make the transfer, but the physician will continue to afford consultation and care in connection with the pending transfer. And it also mentions immunity for the physician, and it says that no healthcare provider subject to any civil, criminal, or professional liability solely for compiling with decision of agent. So that just provides the physician with immunity based on the power of attorney so that they cannot be held liable for any of the decisions made by the appointed power of attorney.